can I just, if your lordships permit me, since your lordships have heard Mr. Mitra and your lordships have, if your lordship give me some time, if I can clarify all these points.
I will hear you, Mr.
I
Bandyopadhyay.
understand.
I will hear you.
I will. These are the points I've already argued by Mr. Mitra.
No.
But
This was not a detailed
I
argument.
am not saying
You are not there.
well, at this stage of motion, there cannot be any details argument. If your lordship thinks that details argument, the matter is disposed of, I don't mind also. I don't mind.
Allow. Just half an hour নেবে? I will hear you last.
No, last means
I will hear you last. Let Mr. Mitra.
let me finish. I don't know. I have also other matters.
Because I have fixed matter after hearing, after taking, after considering that you are available on this. So allow others to make submission in a short campus, and I don't think Mr. Mitra and Mr. Dhod will take much time.
Today it will not be finished.
তো আশা করি সবাই ভালো আছেন। আমি ছোট্ট একটু দেখালাম, পুরো এই ভিডিওটা অনেকটা বড়, 30 মিনিটের প্রায়। আপনাদের দেখার অনুরোধ করব যখনই আপনারা সময় পাবেন, দেখলে বুঝবেন যে এই রাজ্য সরকারের বিড়ম্বনার কেন কারণ এই বিকাশ রঞ্জন ভট্টাচার্য এবং তার যারা জুনিয়র, ফেরদৌস তামিম বলুন, সুদীপ্ত বলুন, বা বিক্রম বলুন, বা সব্যসাচী বলুন, এরা এবং কত ক্রস করেছেন মাননীয় বিচারপতি। কিন্তু তিনি যেভাবে যুক্তির অবতারণা করে এবং প্রত্যেকটি তথ্য নির্ভর যে বক্তব্য তুলে ধরে রাজ্য সরকারকে যেভাবে বিচ্ছেন এবং তার নোটিফিকেশান, আপনারা জানেন যে এই টেন্টেড আনটেন্টেড ক্যান্ডিডেটদের আবার যে রিক্রুটমেন্ট প্রসেস, সেটাকে নিয়েই যেভাবে তিনি সওয়াল জবাব করলেন, আপনারা দেখলেন যে ওই কল্যাণ বন্দ্যোপাধ্যায় তার বিরুদ্ধে যিনি আইনজীবী, সরকারি আইনজীবী, এবং তার হাত পা ছোড়াটা বন্ধ হয়ে গেছে। হাত পা ছোড়াটা বন্ধ করে দিয়েছেন বিকাশ রঞ্জন ভট্টাচার্য। বিকাশবাবুকে তিনি দেখবেন একটা জায়গায় কানে কানে কিছু বলার চেষ্টা করছেন, মানে একটু ভাবা কম সম বলো, যাই হোক, এবার একটু দেখুন।
I will take up first item number 9, which was heard yesterday, but the issue is same in all the matters.
No. Item 9 issue is different from Mr. Bhattacharya.
Very well, Mr. Bhattacharya.
Mr. Bhattacharya has challenged the rules itself. Here, not the rule has been challenged.
In all matters, the rule has been challenged, Mr. Bandyopadhyay.
No,
In 9 also rule has been challenged.
but they are asking for certain. Anyway,
The declaration for
I don't mind, my lord. If you want to hear, I don't mind.
probably Mr. Mitra appeared. I heard this matter, but issue in all the matters is common. Issue is common. Yes. What is your case?
If the lordship thinks that Mr. Mitra should be heard, I don't mind.
No. All are to be heard.
Yes. Kindly turn to page 84. I just meticulously placed the notification to show whether this is per se illegal. In terms of the judgment and order of the Honorable Supreme Court, therefore the source of notification is the Supreme Court order. Source of this notification is Supreme Court order. Read with order of 17th April in MA, so and so, has been directed to initiate fresh selection process to the post of assistant teachers, plus 9, 10, secondary and higher secondary, and to the post of assistant teachers 11, 12. The Commission and Government of West Bengal have already applied for review of the state judgment and order, and this exercise is strictly subject to outcome of the review petition and guidelines of the Honorable Court to be followed by the Commission. This notification is issued for conducting second level, state level test for selection.
Mr. Bhattacharya, there is no confusion with regard to issuance of this notification in terms of the order dated 3rd April 2025, read with 17th April 2025. Now, this is the admitted position. Now, the situation is this, that if 3rd April and 17th April are to be heard, are to be considered together, in that event, there are certain directions given. You draw court's attention to that order.
Yes, I am coming. Yes, I am very happy. Now, kindly come to me, Lord.
Notification আসেনি।
Page 91.
That is the order of 3rd April 2025.
This is the notification dated, my lord. This is 30th of May.
30th May.
Page 1991 is the part of the notification.
Yes.
The kindly, my lord, note this. Eligible candidates.
Which part? Page 19?
By page 91, not 19.
91 plus 2.
2. Eligible candidates minimum qualification laid down in rules 225. Where do they get rule 2025? in connection with the Supreme Court order first. Then,
Eligible candidates with minimum
সবাই
qualifications.
মোটামুটি সব
apart from the
No, minimum qualifications in Rule 2025, which they have framed.
that the
হ্যাঁ, ওই রীতিমতো তাই বলছে।
selection is being undertaken
হ্যাঁ,
in terms
সবাইকে
of the
একটু
Supreme
বলে
Court judgment. The Supreme Court judgment says that 2016 selection should be done.
Where it is said by the Supreme Court.
Kindly come to me, Lord. The Supreme Court order that
After being judgment, Mr. Bhattacharya, come to paragraph
আমি জানি না,
363.
আমি তারপরে
363, subparagraph 2. All appointments granted in the selection process.
yes.
এবার বলে দিল আমার।
Now let us read me out very carefully.
Yes.
All appointments granted in the selection process involve violator so and so are declared null and void.
Then straightway come to 9.
Yes.
11.
Yes.
11.
SSC shall undertake a fresh selection process in respect of the declared vacancies. These declared vacancies are not vacancies
2016. 9, 10, 11, 12.
involved in these three selection process, preferably within a fortnight from the date of declaration results of the ensuing elections. Then,
Then 13.
appointments for
Then 13.
yes,
SSC shall follow the rules governing the selection process
in letter and spirit. Therefore, that rules which was prevailing with the division bench was not declaring this law, and that rule was challenged before the Supreme Court. Therefore, all things were that this is 2016 selection.
Where, Mr. Bhattacharya, it has been directed that new rule cannot be framed.
What the court says that you initiate the selection process of the declared vacancies which were declared then, not new declaration, number one. And number two shall follow
Yes. The declared vacancies,
governing the selection. Which selection?
yes. Rules governing the selection.
Selection.
SSC shall follow the rules governing the selection process.
Letter and
Later.
spirit.
Whatever the rules are there, that
Wow.
is to be followed.
Are there?
That is to be followed. That is to be followed in the next selection process. Now the vacancies. Now tell me, if there are 1600, say if there are 100 vacancies in 2016 selection process for classes 9, 10, 11, and 12. Now in the meantime, if due to creation of certain vacancies, if vacancies are added, this cannot be taken into consideration.
Can I just, if your lordships permit me? Since your lordships have heard Mr. Mitra and your lordships have, if your lordship give me some time, I can clarify all these points.
I will hear you, Mr.
I
Bandyopadhyay.
understand.
I will hear you.
I will, these are the points I've already argued by Mr. Mitra.
No.
But
This was not a detailed
I
argument.
am not saying.
You are not there.
whether at this stage of motion, there cannot be any details argument. If your lordship thinks that details argument, the matter is disposed of, I don't mind also. I don't mind.
Allow me to hear,
No,
then
no,
I will hear.
I am
Sir,
saying, I'm just saying.
I have that on basic prima facie issues. Therefore, this division bench judgment was declared at point of time. When the division bench says that
So according to you, Mr. Bhattacharya, first of all, the declared vacancies should be separated,
Yes.
and a selection process is to be initiated in terms of the recruitment rules of 2016.
because these vacancies would arise because of the cancellation of appointment by the court. Therefore, the court permitted you to do it afresh.
Now, this order merged with the order passed by the Honorable Supreme Court. Let us come to that order.
Kindly come to order of the Supreme Court at page 83.
Paragraph 45 onwards.
Yes. The last question relates to the relief, which it requires, whether it requires any modification. We find no valid ground or reason to interfere with the direction of the High Court that the services of the tainted candidates who are appointed must be terminated, and they should be required to refund salaries payments. Since their appointments were the result of fraud, his amounts to cheating, therefore we see no justification to alter. Then 646. For candidates not specifically found to be tainted, the entire selection process has been rightly declared null and void.
This is for a disabled candidate.
No.
46.
May I read it? Not specifically found to be tainted.
Yes. Yes,
Entire-
please read.
A selection process has been rightly declared null and void due to the egregious violations of the illegalities, which violates Article 16. As such, the appointments of those candidates are cancelled.
Yes.
However, the candidates who are all employed need not be asked to refund or restitute any payments made to them. However, their services will be terminated. Furthermore, no candidates can be appointed once the entire examination process and results have been declared void.
Yes, it is necessary. Please read 49.
Okay, I am reading 49. My juniors will not insist to read 48.
Yes, I am also saying it's necessary. Yes, please.
Lastly, we addressed the case of the disabled candidates. Our attention has been drawn to such cases where impugned judgment had held the appointee so and so shall be allowed to continue on humanitarian grounds. While
No,
we do
page,
not-
paragraph 49 says,
No, I was in paragraph 48.
48.
Lastly, we addressed the case of disabled candidates. Our attention has been drawn to one such case where the impugned judgment had held the appointee so and so shall be allowed to continue on humanitarian grounds. While we will not interfere with this finding, we make it clear that other differently able candidates will not be entitled to the same benefit, as it would contradict legal principles and the rule of law. However, in consideration of their disability, these candidates will be permitted to continue and will receive wages until the fresh selection process and appointments are completed. Then, the disabled candidates mentioned in the previous paragraph will be allowed to participate in the fresh selection process if required with age relaxation and other concessions. Similarly, other candidates who are not specifically tainted will also be eligible to participate with appropriate age relaxation.
Not other concessions.
No,
Only age
age
relaxation.
relaxation.
But in case of disabled, other
Wait, wait.
concessions and age
But we
relaxation.
are not here troubling the court with disabled candidates. In our opinion, such a direction if required, it would allow these candidates to take part in fresh selection process, which should now be initiated to fill the vacancies. Therefore, this is now being
Now, where now I will ask you, Mr. Bhattacharya, where is the bar in framing separate rule?
first of all, don't say that they have no power to frame rules, but that rules will come prospectively. Here, the declared
No, in terms of the order of the Supreme Court.
Supreme Court always says, Supreme Court passes on at the point of time when the rules are prevalent.
Yes, but Supreme Court did not expressly debar
Did
the
not-
state authorities or the
question
recruiting
did not
authorities
arise.
from framing rules.
These questions did not arise at all. My lord will have to consider that when court is passing an order, keeping the law as it was then available. And when court found that the appointments of a particular selection is bad, court is permitting to do that selection afresh. If you do that selection afresh, you have to go back to that situation. You cannot come back later and bring something new. That would be really betraying the confidence of the court with the authorities. Therefore, 2016 selection should be made in terms of 2000 selections.
That is your submission.
That's my submission. And then kindly come to me, Lord. একজন বলতে দেবো আমাকে?
Yes.
Accordingly, paragraph 51, we uphold the impugned judgment cancelling our block entire selection process, but have made certain modification in the direction issued by the High Court. The appeal this was so and so. However, we independently take up the issue raised in filed by the state. That's a different issue. Now
Come to 17th April order.
now kindly come to me, Lord, the application filed by them before the Supreme Court.
And the 17th April order is
Yes.
German.
MA, kindly come to me, Lord, MA. Pursuant thereto, a letter dated 22nd of April was sent by the Commissioner of School Education to all the district inspector schools in district, informing them about the order dated 17th April. Thereafter, the letters dated 23rd April were sent by the DI to all schools in the district, sharing a list of the assistant teachers who were not found to be specifically tainted. It is submitted that the names of the applicants do not find place in the said list. It কোন application দেখা যাচ্ছে?
But this is referring to 17th April 2025, Mr. Bhattacharya. We are on the order date 17th April 2025.
Kindly excuse me, Lord, I am misled by my juniors, unfortunately. Kindly takes up the application filed by the board.
This court is on 17th April 2025 order
Yes, the 17th April order was passed.
on an application.
I am not.
But this cannot be
No,
that
No,
application.
no, I am extremely sorry.
Yes, yes.
I'm extremely sorry. My lord, the application is at page কোথায়? Look, this application was filed by the copy দাও তো ওখানে? By the state. তোমরা রেডি থাকো না Lord, I just read out the relevant portion. It is stated that, Lord, the page, paragraph 5 of the said application. Steps are being taken in terms of the judgment for filling of the vacancies which have arisen on account of the, well, I can note this, which have arisen on account of the selection process having been set aside. The applicant is informed that a letter dated so and so addressed by the state government to the West Bengal Central School Service Commission issued. By way of instant application, the appellant most humbly craves to seek appropriate directions and modifications of the judgment to permit the appointed candidates not found to be tainted to temporarily continue in the various schools without claiming any equity in their favor until the end of the academic year or until the process for fresh appointment is concluded, whichever is earlier, so that education of these schools does not suffer. That's the application. Now, my lord, I do not replace the other paragraphs, which is not relevant. Kindly see what are the prayer made. Prayer was permit the appointees not found to be tainted to continue in service till the end of the academic year or until the process of fresh appointments to such posts. Underline this word. Appointment to such posts is concluded, which was earlier. On the basis thereof, the Honorable Supreme Court passes an order at page 86.
That is 17th April order.
Yes. We are inclined to accept the prayer made in the present application insofar as it relates to assistant teacher of classes 9, 10, so and so, not found to be tainted, subject to the following conditions. An advertisement for fresh recruitment to the aforesaid posts, no addition, shall be published before 31st of May 2025. Then the examination and entire recruitment process shall be completed by 31st December. These are the two things, Lord. Supreme Court says do it to those posts by 31st May and complete by 31st December. Until then, the non-tainted will continue and get this.
I will permit you to read the rest of the
Yes.
orders. Now the problem is this: today, if court interferes with this selection process by making an observation or by setting aside this notification dated 30th May 2025, would it not lead to relaxation of time schedule fixed by this Supreme Court?
With deepest of respect, the court order, my lord, is not to be observed only to maintain the time schedule. The court order, my lord, has to be observed, and it is the duty of this court.
It is absolutely correct. It is under true letter and spirit. Now, but when with a default clause in 17th of April, this order was passed, then where is the scope left open to this court?
Yes.
To today, suppose hearing both sides, I set aside this notification dated 30th May 2025. Now that lead to relaxation of the time schedule or extension of time schedule by this court, that is according to this court is not open in view of the tenor of this court order dated 17th of April 2025.
But if your lordship finds that the first paragraph says advertisement for those posts is violated, will that be permitted? When the honorable court, my lord, is really thinking in terms that I have to.
That is troubling this court.
No, the court has to, my lord, set aside. The Supreme Court judgments are there. Article 144, my lord, comes into operation. This will be duty of the High Court to ensure that the Supreme Court order is, my lord, followed. Here, my lord, in the name of following the Supreme Court order and to avoid the, my lord, wrath of the court, they have issued a notification. And if that notification seems to be apparently illegal, would the court, my lord, feel shy of not interfering? We want, let the time schedule as such be maintained, but you correct your notification. This can even be done by corrigendum. We want that this Supreme Court order, my lord, should be complied with.
Come to paragraph 3.
Yes. The state government, the applicant, West Bengal Board Education and the West Bengal Central Submission shall file their respective affidavits by 31st May, enclosing that with a copy of the advertisement for fresh recruitment, as well as the schedule therefore, so as to ensure completion of the recruitment process by 31st December. In case the advertisement is not published by 31st May and the affidavits are not filed, appropriate orders will be passed by this court, including imposition of cost. Now, to avoid this imposition, they have published a notification that's 31st May. But is that the notification?
Now, what is the effect of the order passed by the Honorable Supreme Court dated 17th April 2025? That do this by this time, file an affidavit. So therefore, Supreme Court is still in session of the matter.
So it's not session the matter. The Supreme Court dispose of the matter. Finally, it comes to us.
Then what was the purpose of calling for an affidavit disclosing initiation of the selection process by issuing this recruitment notification dated 30th May?
To ensure that this is done. Otherwise, the application could not be disposed of. Kindly see last time, the misapplication stands disposed of in the aforesaid terms. Court did not, my lord, keep any, my lord, control over the proceedings anymore. If it is to be done by another independent application. Now today, I was thinking aloud that if the honorable court
Even Mr. Bhattacharya, even after disposal of the appeal by order dated by judgment dated 3rd April 2025, this miscellaneous application was entertained.
was by the state.
Yes. So then
But
where is the bar in approaching the Supreme Court for getting appropriate clarification?
we cannot approach. And
But at the same time, the hand of this court is tied
No.
in view of the time schedule framed by
I
the
will
Supreme Court
satis-
with a default clause, Mr. Bhattacharya.
my lord, kindly forget that the court is only bound to maintain the time schedule. Kindly think, court here sitting in the constitutional jurisdiction is my lord, also would be kind enough to consider
That a rule of law must be
whether
must
the
prevail.
Supreme Court
Yes.
other directions, Supreme Court others directions in merit is not followed or not. Date is not only something with a directive. If the
But tell me whether this date extension of time can be
I am not
can be
asking.
relaxed.
I am not
Because
asking.
today we are in the mid of July.
Even then.
Now, if I set aside this notification dated 30th May
So I
2025,
don't say, need not be set aside.
then it will lead to extension of time for issuance of notification. Then today the resultant effect would be court has to give a direction upon the recruiting authorities and the state to frame a notification within fortnight or within 1 month. That will not lead to extension of time fixed by the Supreme
That
Court.
then the obligation would be upon the state and other parties that since this is the order due to, can you extend the time? But fundamental task would be,
So when you are approaching before this court, you approach the Supreme Court for extension of time.
why should you? I have to first get a view that this is illegal. Supreme Court doesn't have the original jurisdiction to entertain a new notification. My lord is well aware that I cannot straight away go Article 32 petition filing a challenge notification. It would not be governed. Therefore, I have to approach the jurisdictional court, and if the jurisdictional court finds that this is illegal, then consequently I can approach the Supreme Court saying, now kindly, my lord, now since this is the order that here also on 13th of April, 17th of April, Supreme Court categorically states, you follow recruitment process to that post.
Advertisement for fresh recruitment to be made.
Therefore, if those posts,
Where which paragraph? Clarify that all orders will.
now will kindly come to me, lord. Advertisement for fresh recruitment to the aforesaid posts. Aforesaid post means, my lord, the 2016 selection. Therefore, if it is confined to 2016 procedure and law, there's no difficulty. Even today, they can issue a notification that this was a mistake. We will follow only 2016 rules and the vacancies.
And if aforesaid posts are clubbed along with the subsequent vacancies, where is the bar in the order?
Because under the rules, recruitment rules, you have
And how this can be restricted to the candidates of 2016?
because
that will in contravention of Article 16.
not at all.
This is a public
Post,
employment.
well, the public employment for the vacancies declared. This is not a new process. This arises because of intervention of the court. Had the court not declared the selection was over, then these new vacancies wouldn't have come. Kindly consider this.
But nowhere division bench and Supreme Court has said, Mr. Nowhere, that this selection process has to be conducted in terms of 2016 SLST rules of 2016, and it would be confined to the vacancies.
That I will then again.
Nowhere it has been
I will
observed.
again invite your lordship to read the judgment in its entirety. But what was the issue before the court? Kindly excuse me without repetition. That 2000 selection is bad.
Yes.
Now court finds 2000 selection is bad. Now court says do it afresh to those posts. Therefore, the rights of the parties which were there accrued at 2016 would be considered. The subsequent rights would never be considered because these vacancies were there in 2016. Categorically, High Court and Division Bench and Supreme Court says to those posts. Therefore, if it is confined to those posts, it will be confined to the persons who were then eligible. Otherwise, if 2016 election was not set aside, the subsequent vacancies, subsequent rules wouldn't have come into operation to tag with this. Couldn't have been. Therefore, reasonable and logical conclusion is that you have to hold afresh for 2016. Do it. We do not say that you cannot hold the examination.
So therefore, your sum and substance of your submission, Mr. Bhattacharya, is this first, these vacancies of 2016, 9, 10, 11, 12 are to be treated separately, and for filling up those posts, this separate selection process is to be conducted following 2016 rules.
That's the judgment, number one. And number two, kindly will not again come back to the impute notification. The notification is still inherently bad.
Because
And the Supreme Court, my lord, makes it very categorical that the tainted candidates would be barred.
Yes,
Prohibition.
that's
And you have allowed everybody to participate. Number one. Now, kindly come to the notice is inherently bad.
just half an hour নেবে
Now, kindly, my lord,
now notification. I would ask Mr. Bandyopadhyay two things. First of all, where is the prohibition prohibiting the tainted candidates to participate? There is no such prohibition. And another thing I would ask Mr. Bandyopadhyay to clarify that if you come to the mark provision
yes.
relating to allotment of
That
marks,
I was going to show.
now they are
Inherently bad. You are
that
clearly
is
classed among
also, first of all, there is no express prohibition prohibiting the tainted candidates to participate. That you will, I know you will take this point. And the second is
distribution of marks.
distribution
How
of
could
marks.
the additional marks for teachers comes? Thereby, you want to give benefit to those who have been declared null and void by the Supreme Court.
This prior teaching experience,
Yes.
whether 10 marks can be allotted,
Yes.
who has lost their job with the finding that there is egregious fraud. So how this can be reconciled?
And then again, if it is below the open recruitment for fresh recruitment,
10 marks for experience. Now, if a teacher who has rendered job in connection with 2016 SLST 9, 10, 11, and 12, how they will get
that
the
is,
marks?
you have correctly marked this. And then again, the distribution of marks was also changed
That I have seen.
to create another door for corruption. I use this expression with all restraint. And
Is there in the notification any provision that the tainted candidates should not be?
And this rule is published on 29th of May 2025. 29th May 2025 is the rule, and
30th May is the notification.
And there you say that we have additional vacancy in terms of 2025 rules. How could you arrive at the vacancy? If the rule was published on 29th of May and rule gives the detailed procedure for ascertainment of vacancies, how could you on the next day get the vacancies?
But I do not, Mr. Bhattacharya, find fault with clubbing of vacancies along with subsequent vacancies. If those vacancies are included, matter ends. But the question is, where is the embargo
When the vacancies are included, you are
clamped upon the untainted candidate, tainted candidates?
Lord, that is one part you have already taken note of. When you are adding the new vacancies, you are inviting fresh candidates. Now, Lord, you see the classification is so irrational. When you say that I add these additional vacancies, then you are inviting the fresh candidates who would be eligible today, and they will be putting in competition with the 2016 candidates.
Yes.
Is that fair? The Supreme Court and High Court says those vacancies only. Apart from the question of distribution of marks, would that be fair? And when the Supreme Court and High Court says those vacancies only, because this is a fresh test of the persons who had participated. Today, they are thrown out. One group is completely banned, but another group is permitted that you participate and prove your worth. That's why the rule says every year you have to assess the vacancies and publish the advertisement so that the fresh recruits can come and compete with the same vacancies. And clubbing of these two vacancies of 2016 and 2025 would be irrational and violate Article 14. You hold the examination separately for 2025. No problem. The fresh candidates will come and contest. Otherwise, you'll be putting us in difficulty, who are really the genuine candidates contesting 2016. Now, this notification, my lord, can even today be modified, corrected to respect the time schedule by the Supreme Court. 31st December, long way to go. Only little modification that the portal is such that who have already crossed 40 years, they are not permitted to file. Though the Supreme Court says age relaxation should be given, the notification says the age relaxation as well Supreme Court. If I am not allowed to enter, how would you assess whether I am age bar or not? Therefore, my lord, if your lordship, my lord, just conclude, my lord, I will not take as prima facie case. The division bench judgment and the Supreme Court judgment, the court was always conscious of the fact that this 2016 should be done afresh. Nothing beyond that. Let them do it afresh. With the guideline, the tainteds are out, and the age relaxation to the persons who had participated.
Yes,
not
that
all.
is there in the
No, but portal does not will not permit me to enter.
age relaxation. Already there is a direction.
There is a direction, but not I cannot apply. The portal says they were barred.
Overaged.
Therefore, the portal should also be, my lord, corrected. Here also, my lord, when the Supreme Court is very categorical, they fill up those vacancies and remove the untainted candidates, give the age relaxation. All these three criteria have been violated. And that too notice in the name of Supreme Court. Kindly do not set it aside, let them do it afresh. Or my suggestion before the court would be that these things can be corrected even today. That will not take much time. The correction can be done within 48 hours. The applications can be invited, the process. 31st December is the last date for holding examination. If any difficulty, let them say that we cannot do it by 31st December. We will remain approach the Supreme Court saying kindly extend the time because we are interested to get job. But these are my points.
I will hear you last.
No, last means,
I will hear you last. Let Mr. Mitro.
let me finish. I don't know. I have also other matters.
Because I have fixed matter after hearing you. After considering that you are available on this. So allow others to make submission in a short campus, and I don't think Mr. Mitro and Mr. Dhod will take much time.
Then today it will not be finished. Today will not be matter will not be finished. After 12:30, I will not be available. Then in that case, your lordship.
No, it will be concluded. Yes. Wait.
I have to accommodate. Then just a minute.
Yes, Mr.
Coming
Dhod.
for 2 minutes. With
Yes.
your lordship, just I am coming for 2 minutes.